Good afternoon, everyone. Welcome to our webinar today, discussing the new changes in employment law. I'm Vinay Patel. I'm the co-founder and managing director of PredicAire, and we are here today with our friends from Hill Dickinson, a very well-known law firm with two amazing partners who specialize in employment law. As an operator of care homes, we already operate with razor-thin margins and a huge workforce challenge, including shortages as well. And therefore, these reforms that are coming through, which is the biggest shift in employment rights in a generation, really keen to understand what do they mean in practice. And this is why we've arranged this amazing webinar for you guys. Thank you. I'll then now introduce you to Sandeep, who's a partner at Hill Dickinson.
Thank you, Vinay. Good afternoon, everyone. I'm Sandeep Crowd, a partner in the corporate team, working closely with many of you on transactions in the care sector. Employment rights are a huge part of what shapes workforces' risk in deals. So changes we're discussing today have real commercial consequences for many of you as organisations. We're really pleased to have a number of clients and sector contacts with us on the call, and I'm sure you'll find today's insights genuinely useful. Before we go into the main part of the presentation, there's just some housekeeping that I'd like to take you through. Please just make sure your microphones are muted and cameras are automatically switched off anyway. If you have any questions, please just submit it in the Ask a Question box. We'll try to answer some of them as we're going along, but there will be time at the end for us to get through as many of them as we can. And so please don't be afraid to ask any questions as you go along. The webinar is being recorded and it can be accessed using the joining link, and a copy of the slides can be downloaded from the presentation slides box as well. So if you want to have a look at these slides afterwards for a refresh, please do so. Feedback is really important to us. So if you can complete the survey at the end of the webinar or click on the Give Feedback button at the top of your screen, that would be really helpful for us. These webinars are very bandwidth intensive. So if you can close all of your other programs you've got in the background, it will just make everything run smoother. And if you do find that you are lagging or the slides are lagging, if you press F5 on your keyboard, that should refresh any issues you have. And also, obviously, make sure your computer speakers are turned up and so you can hear what the presenters have to say. Enough of that. So let me now pass you forward to two partners in our employment team who specialise in this area, Caroline Prosser and Padma Tadi-Booth, who will take you through for the rest of the presentation and provide you with all the information that you need. Thank you.
Thanks, Sandeep. So as Sandeep advised, we're going to look at the Employment Rights Act, which is huge. So what we've done is we've really picked out some topics that we think are the most relevant to your sector. And on the slide, you can see the agenda of what we're going to go through. And what Caroline and I will do is just take it in a bit of a time order. And you can see that the next set of changes are not that far away in April. And then we'll look at October, January, and then a bit further ahead. So before we delve into the actual details of the Employment Rights Act, it's probably worth having a moment just to reflect on the timeline of how we've actually got to here. So after its introduction in Parliament back in October 2024, the Employment Rights Bill was really heavily amended in lots of different respects to effectively try and get it through, which again, Caroline and I will touch upon as we go through of where we saw some amends from the initial stark announcements that were made by the Labour government as they came in. Ultimately, there was a prolonged period of parliamentary ping-pong with the Act before it was ultimately passed just before Christmas. And as we've alluded to in the agenda slide, the implementation will come through in phases. The first implementation actually happened a fortnight ago, or just over that, on the 18th of February, and that was mainly introducing new rules around trade unions and industrial action, which we'll touch a little bit upon today. But ultimately, that in itself is a huge topic that we can probably spend the whole afternoon talking about if you are in a unionised industry or business. The next set of major changes, though, and the wave, as I say, come through in April when we start to see a series of day one rights and something known as a Fair Work Agency is going to be created. Finally, the remainder of the Act then comes through in succession in October and then the 1st of January, and then a few smaller waves throughout 2027. So let's start with April 2026 and what we can see here. The first major change here is going to be on the 6th of April with the entitlement of statutory sick pay, which is you need 3 waiting days at the moment in order for SSP to kick in, and SSP currently being £123.35 per week. From the 6th of April, that will kick in as a first day of absence right. Low earners who previously would have missed out on SSP because, again, currently you have to have a lower earning threshold limit. And if you don't hit that, which is £129 per week from April, that people weren't allowed or currently aren't allowed to get SSP if they earn under a certain threshold. Now, from the 6th of April, that threshold will be removed. It'll become a day one right. And so that means that people will receive whichever is the lower of 80% of their earnings or the fixed SSP rate, which going back, as I say, 123 at the moment, going up to 129. Putting aside the additional cost of funding those extra 3 days, what we think will happen is that this measure may have an ultimate impact on absence rates. So if you currently pay statutory sick pay only and apply the 3-day waiting rule that currently exists, when that goes, you will see an increase probably in intermittent short-term absences. And that's because staff who were previously taking 1 or 2 days sick would probably have forced themselves into work because they wouldn't get the minimum of even an SSP entitlement. And for many staff, especially in the sector that we are currently focusing on today, that is unaffordable. So as I say, people would probably attend work with slight sniffles and those sorts of things. From April, because people will be entitled to SSP from the first day of illness without that lower earnings threshold as well, they might be more inclined to start taking a day off here and there, which they historically might not have done. So what do we think businesses should be focusing on in light of this? Well, for us, we are working with a lot of clients to look at their absence management procedures and making sure that they are robust. It may be something as simple as making sure that you do return to work interviews after each and every absence, making sure that you're on top of those things, looking at understanding what those patterns of absences are and why, because ultimately, if someone is accountable for those periods of absence, they may feel less inclined to take that absence, as we say, for small sniffles, aches, etc. But also looking at what your trigger management processes will be of when you start looking at following absence procedures for warnings or anything of that nature, taking into account any reasons for disabilities for those absences. But ultimately, looking at your absence management procedures is going to be really key as we come to that 6th of April date. Also, in terms of that policy that you have, usually and typically in your handbook, make sure that if you are making references to 3-day waiting periods or lower earning thresholds, that these are amended and brought up to date to reflect those changes. If you have part-time or 0 hours workers, it's also, again, really important to ensure that the contract specifies what the qualifying days are for statutory sick pay. Now, there must be at least one qualifying day in each week that is accounted for in the contracts. So if the employer and the employee cannot agree on what that qualifying day should be for, as I say, part-time, 0 hours or variable workers, because if you've got someone who's on a a regular contract, so your typical Monday to Friday, or part-time Monday, Wednesday, Friday, whatever that may be, it would be the days that they normally work is what you'd put in the contract. But for part-time, 0 hours or variable, that can be a bit more difficult. So you have the employer or employee trying to agree what those qualifying days are, but if not, regulations kick in to provide for what the qualifying days would be. And that's either going to be the days on which the employer and employee agree that the employee is always required to work under the contract, a Wednesday if there's no specified day of work, or every day of the week except the days on which no one within the workforce are required to work. So if the business that you're in closes down completely on a Sunday, then it'd have Monday to Saturday as those working days. So you can see that if you've got a failure to specify what that qualifying day is and agree that within the contract of employment that you give the individual, it gives the staff an opportunity, if there is a dispute over whether they're entitled to statutory sick pay or not, to argue that they should have been paid statutory sick pay using one of those three that I've just mentioned in terms of what their qualifying day should be. So the thing that we would always say with contracts and terms that you give to employees, not just about sick, but anything else, it's always important as an employer that you properly nail down what that wording is and you are very clear in unambiguous terms, because any ambiguity in a tribunal would always be construed against the drafter, i.e. the employer, and therefore it's really important not to always just rely on templates that you pick up off the shelf or anything of that nature without really clearly thinking about how that fits within your own business. You also might want to think about making changes to how shifts are booked, especially for workers once they're sick, so that you can limit that ongoing entitlement to statutory sick pay. And again, that's something that Caroline are already working with some of our businesses of how to strategically put in place those policies, procedures, and just those strategic methods to try and limit your exposure. Because as I say, otherwise, you may end up in a situation where workers will continue booking or accepting shifts knowing that they will be unwell, but do that in order to get SSP payments. The next thing that will also become a day one right is paternity leave, and the impact of this change will be mainly limited to new hires who currently find themselves excluded from paternity leave, because currently you need 26 weeks service in order to qualify for 2 weeks paternity leave. And as I say, it impacts those new people that may switch jobs partway through a pregnancy or an adoption. However, as they will only qualify for unpaid paternity leave, I'm not sure how much of an impact this legislation will really have in practice. But what it does do is it means that people are entitled to take that 2 weeks off currently where there is that limitation. To be entitled to statutory paternity pay, whilst they can take it off unpaid in that from day one, for paternity pay, they must have that 26-week service. So that in itself isn't going to change with this new regulation. Some employers may choose to offer paid paternity leave from day one, but that isn't mandatory. But I know that some businesses do that as an incentive to bring people into the business and so on. Currently, in most cases, paternity leave is taken around the time of birth, but fathers, partners, whoever is eligible to take paternity leave can take it at any point in the first year of birth or adoption, or in single blocks of 2 weeks or 2 separate blocks of 1 week each. The Act will, or the Employment Rights Act that's changing or coming into force from April 2026, does make a small tweak to that, in that interplay between paternity leave, and shared parental leave. Employees currently lose any entitlement to paternity leave and pay if they take a period of shared parental leave first. The bill rectifies that by allowing employees to take paternity leave and pay even if they've already taken a period of shared parental leave. So if you just remember, shared parental leave is where you can share that period of absence with the primary adopter or the mother of a child on birth, where you can take some of that year-long entitlement that a mother or a primary adopter currently gets. And currently, as I say, if you don't take the paternity leave first before the shared parental leave, you lose the entitlement to paternity leave. The bill, as I say, rectifies that, so you can take it in any order that you want. Again, I'm not really sure how much this change is going to have a big impact on people, because most HR teams will probably guide the employee to take paternity leave first and then shared parental leave. But ultimately, what this does is, if for whatever reason one right has been exercised before the other, it doesn't detriment the access to paternity leave as it currently does pre-6th of April. So under the transitional provisions that we're going to have here, children born on or after the 6th of April, or children born prior to the 6th of April, but whose expected week of childbirth starts after the 5th of April. So here we're talking about children that are born prematurely, or children placed for adoption after the 6th of April, or children whose primary carer dies on or after the 6th of April, regardless of when the child is born, will be entitled to this day one right. So the thing here is really just to be aware of the changes, be aware that it's the leave is a day one right, but it doesn't impact the paid entitlement. But ultimately your policies around paternity leave in your handbook will also need to be amended to reflect these changes. The next day one right that I wanted to talk about, again, coming into force from the 6th of April, is rights to unpaid parental leave. So employees currently need 1 year's service in order to qualify for this unpaid leave, but it becomes a day one right from the 6th of April 2026. 18 weeks is the total lifetime allowance of a parental leave per child per parent. If you switch employer and you start your new employment with whatever your reduced balance of parental leave is, you take that reduced leave. You don't get your 18 weeks in total back again. So to give you an example, if you take 4 weeks with one employer and then move to employer number 2, the balance that's left with employer number 2 is 14 weeks. If a worker has more than one child, they can take more than 4 weeks unpaid parental leave per year by splitting that time taken between their children. So for example, you can take 4 weeks for one child and 4 weeks for child number 2. Because as I say, it's per parent and per child. The leave should only be used for the purposes of caring for a child, and it should only really be taken in blocks of 1 week or more at a time. However, if the child is disabled, so here we mean in receipt of Disability Living Allowance, or PIP, the Personal Independence Payment Programme that's in place, then an employee can take it in blocks of days or even hours for that disabled child. But with any unpaid parental leave, whether your child is disabled or not, the amount of notice that has to be given remains the same, and that's always at 21 days. Again, the impact of this change is going to be limited to new hires, so those who have less than that year's service, where historically or before the 6th of April they won't be able to take parental leave. Now, from day one, people can join and then immediately start applying for parental leave as needed. Now, it tends to be, in our experience, that it's quite limited for people to take parental leave because it's unpaid. And so again, it depends what earnings threshold someone's in and the means that they have on a personal level. So again, just question what impact this will have, other than, as we say, people might start asking from day one, which is something you need to be aware of. And again, as before, a note to look at your staff handbooks and policies around this. We've then got the Fair Work Agency, which a lot of you may have heard being bandied around about, this new single enforcement body that's being created. And that is due to be created from the 7th of April. And what the Fair Work Agency will do is have these wide sweeping powers to come in, inspect workplaces, undertake targeted and proactive enforcement actions, bring civil proceedings, act against any worker exploitation where they think there is exploitation around hours of work, rest breaks and those types of things. And they'll be responsible for enforcing those basic worker rights. And the typical issues that we tend to see in the care sector where legislation is inadvertently breached tends to be around holiday pay. So we tend to do a lot of work around holiday pay in lots of different industries, because in 2024, at the beginning of 2024, there was a change in legislation, which effectively suggests that if someone is paid a shift premium or overtime pay or get performance-related bonuses, those extra amounts that you're paying the individual should be taken into account when calculating holiday pay. Typically, not just the care sector, but lots of other places tend to just calculate holiday pay based on basic salary only and what that basic rate is. And actually, by doing so, businesses are inadvertently in breach. And so, as I say, we typically see it in the care sector where when calculating holiday pay, care businesses are not taking into account shift premiums, i.e. Rates for night shifts or working at weekends where people might get premium or late shifts, or overtime pay. And so that's where, if you're not doing that already, again, we are more than happy to have a chat with you. And as Sandip mentioned, there's feedback forms, there's chat functions here. Please do reach out to us, and we're more than happy to pick up with you separately around doing an audit for your business and looking at what your exposure is in this regard, and also just how best to rectify those issues if you have them, and really look at what your cost base is and should be. National minimum wage, again, that typically tends to be an issue because of not necessarily fully tracking working hours correctly, or if people are travelling to different sites or different people's homes, of what should be calculated as working time, and therefore does that feed into how you're paying national minimum wage. Statutory sick pay, which we've already spoken about. But the Fair Work Agency can also look at enforcing tribunal penalties, any labour exploitation such as modern slavery and those types of things. So the Fair Work Agency will have lots of legal powers where employers are in breach, including powers to issue notice of underpayment, going back to failure to pay national minimum wage correctly, statutory sick pay, or even this holiday pay issue. Now, the Fair Work Agency can go back up to 6 years for any of those underpayments, but there is a merging case law around holiday pay where actually it can even go further back if individuals were to bring claims. The other important point to make is that the Fair Work Agency doesn't have to rely on the individual complaining or bringing a claim. So the Fair Work Agency can come in and of their own volition, even if the individuals don't want to complain, bring a claim or grumble, they can say this isn't being done correctly, and therefore we will bring action on behalf of the employees. So typically we currently rely in certain circumstances of the goodwill of the employee, or the fact that they're unlikely to grumble because it might not be worth their time, they might not be savvy enough to bring such a claim. The Fair Work Agency is intended to come in to sort of tackle all of that and enforce those worker rights that people may not know about or not be fully au fait with. The Fair Work Agency can issue penalty notices of up to 200% of the underpayment, so a minimum of £100 and a maximum of £20,000 per underpaid worker. As I say, they can bring employment tribunal claims. They can also provide legal assistance to workers to recover costs and do things like that against the losing side in these things, and look at enforcement actions. So if an employer defaults in terms of paying any compensation, things like that to individuals, they can look at helping support in relation to that. Now, that's a lot of or a wide remit that the Fair Work Agency will have. Now, they will be established on the 7th of April, but we're not yet clear of when it'll become fully operational, because we're not quite sure how it's going to be fully manned either. Some of the things that we've spoken about HMRC or the Health Standards Agency will usually enforce some of those things. So we're not quite sure whether they'll probably start pulling people in from those various governmental bodies to pull them in to then create this Fair Work Agency. But I just don't think there's been enough out there of how they're actually going to man and enforce and know about some of these issues. What we do expect is that there may be some tipping off helplines for workers to anonymously report, because otherwise I'm not sure that there will be enough resource within the Fair Work Agency. A bit like HMRC when various changes to IR35 and those sorts of legislation came in, that I'm not sure that they'll be resourced enough in order to be able to just go out and start taking all this action, and they'll not have enough manpower. So the best way to do that, in our view, is probably tipping off lines. But again, watch this space. And then my final slide that I want to touch upon before I hand over to Caroline is around protective awards, whistleblowing and trade union recognition. So protective award, failure to inform and consult in a collective redundancy scenario. So you may be aware that if you are proposing to make 20 more redundancies within a 90-day period, you have to undertake what is known as a collective consultation period, where you elect representatives if you're not unionised, and go through minimum consulting periods before redundancies can take effect. Now, if you fail to follow the step-by-step process that you're meant to follow in these circumstances, currently the penalty is 90 days uncapped pay per affected individual. That will double to 180. So the cost of not getting it right will significantly increase. And we do see from time to time, because of either emergency situations, not having time, or looking at calculating what the maximum exposure will be, and an employer willing to take that risk, sometimes employers will just say, do you know what, we know what the likely award is going to be, let's still breach or not do some of the steps. Now, it obviously becomes significantly more important in terms of the cost impact for you as a business if you were to fail in doing any of those steps. Whistleblowing, there's going to be a change where disclosure of sexual harassment will class as whistleblowing, and that's where it has occurred or is likely to occur. That, as I say, that will fall within the definition of being a qualifying disclosure for whistleblowing purposes. It's still going to be necessary that for whistleblowing purposes, that the worker has to still reasonably believe that they're making that disclosure in the public interest, and still make it to the right body to making disclosures to the employer or prescribed persons as set out in the legislation. But ultimately, what the change is doing is it just widens the remit. Again, I would question, whilst it was quite a headline term that this is now included and this is what's being done to minimise or to protect people that are raising issues in terms of sexual harassment, I do question how much this will really change things, because I do think that it's already strongly arguable that a disclosure relating to sexual harassment should already be classed as protected. And I've not seen anything or any cases come through where it was denied to the contrary. But what it does is it just makes it even clearer that when someone is raising an issue of sexual harassment and how that's then dealt with and any impact of that, brings that bit more of a guaranteed situation that it's likely to class or runs risks of whistleblowing, where you need to be extremely more mindful of it. Just as a reminder, various changes came through or have come through following the hashtag #MeToo movement in terms of confidentiality clauses in NDA agreements, and then being void if it's to try and close down discussions around making protected disclosures, especially relating to sexual harassment. And again, the regulations that have come through will just carry on making that tighter to stop someone or gagging someone in a non-disclosure agreement. And then finally, trade union recognition. There will be a simplification around the ability for trade unions to ask to be recognised. So currently, you need a 10% support threshold for a body to then to be able to apply as a union to say, I want to be recognised in this employment sphere with this employer to be a recognised trade union for them. That is likely to change to go somewhere between 2 and 10%, but we are waiting for further details. But what the change from 6th of April is, it allows the regulations around it to be amended to lower that 10% threshold. So I'm now going to hand over to Caroline, who's going to look at October 2026 changes.
So the next major implementation is expected to take place in October, and we're basing this on the government's timeline, but this remains subject to change. It's really important to remember that what Padma's talked about is the changes that are coming in on the 6th of April, and they are definitely coming in the form that Padma has said. The changes that are coming in October and the ones that we're going to talk about coming in January, we are still waiting some details of these before they come in. So the most important thing to keep up to date, if you sign up to our newsletters, we send out regular articles when things change. Also, if you're on LinkedIn, please follow Padma and me, because Padma and I, we do a lot of posting about updates, and sometimes we post about things that are consultations, things that are happening in consultations, which give you an idea about the way things are moving. So I'm going to tell you about what's coming up in October, but like I say, please keep up to date with us, because we will take you through this as it happens. There will be some things that will only come into place just before the changes in October, and things are rapidly changing all the time. So the first thing I'm going to look at, in this particular to the care sector, is that the Employment Rights Act introduced new powers to establish a fair pay agreement process for the social care sector and for the creation of social care negotiation bodies. So the negotiation bodies are going to be able to negotiate minimum pay terms, other terms and conditions across the social care sector, similar to national level collective bargaining. So they're wanting to set out some protections for workers in the sector. This is going to set the minimum benchmark terms and conditions. So it's basically looking at those, the government have looked at those areas where they feel that this sector, the people working in their sectors, are more vulnerable, and they're looking to protect them. They're also doing it with school staff as well, the support staff, but they are looking at the care sector. Regulations made under these powers mean that the existing terms and conditions cannot be reduced, and it cannot be it's completely preventing it's making sure there's a baseline, basically, so we can always offer more favourable update for our social care workers. So this is effectively setting a minimum terms and conditions, and it's not to stop us as an employer of choice if we want to offer better. So a social care worker is going to be defined slightly different in England as it is in Wales, so in Scotland. So in England, it's a person who is employed wholly or mainly in connection with the provision of social care to individuals aged 18 or over. Whereas in relation to Wales or Scotland, it also includes any individual, so it includes those under 18 as well. We are going to wait for regulations to see exactly what individuals and which sector are going to qualify. So there's a little bit of work to do on this, as Padma said. It's the same with the Fair Work Agency. This social care sector body is going to be set up in October, but we need some regulations to determine who's going to be within scope and how it's going to work. So although the powers will come into force in October 2026, the government expects the first negotiations on pay, terms and conditions and other matters such as training and career progression are going to be held in 2027. So this means that the first pay agreement itself, which will apply to everyone, is probably going to be implemented in 2028. So we've got a little bit of time yet. Like I say, it's going to be set up in October, and then we've got a bit of time before it'll actually start governing the terms and conditions. So again, keep an eye out for our updates, because we will go through as we find out more about this, so that as a sector you are prepared and ready for this. The second thing, big change that's going to take place in October is there's going to be an increase in the time limit for employment claims to be lodged. So at the moment, if you have an employment claim, you have it was always 3 months to bring a claim, and then you had this ACAS pre-conciliation period, which originally was a month. So that meant, employees had roughly 4 months before they were timed out of bringing a claim. Now this 3 months is going to be extended to 6 months. And we also had in December the pre-conciliation period extended from the 1 month to 12 weeks. Now, I'm not sure if anybody here has tribunal claims, but you're probably aware that the tribunals are really backlogged. They're really struggling at the moment. We're having cases at the moment that are listed in 2029 for pre-hearing reviews, not even the full substantive case. So the idea was, I don't know if anybody's had any kind of claims being issued recently, but ACAS always had the time to do these pre-conciliation negotiations before claims were issued, but they just had so many claims coming in that often ACAS weren't even able to negotiate, and the certificates were just being issued and the employees were just putting claims in without any time for negotiation. So the government increased in December the time for ACAS to conciliate for 12 weeks. Add the 12 weeks to this 6-month period instead of 3 months, and the wait to see if one of our employees is going to bring a claim will increase, and it could potentially be around about 10 months before we know. If you factor in the early conciliation and the fact that claimants always have a clear month at the end of the early conciliation period to bring their claim, also the fact that we don't always hear from the tribunals in time. Often there's so many claims going in the tribunal that the claim might go in on a date that then the employer might not find out about it for another 2 months. The employer always gets a month to respond, but sometimes we're not getting the claims actually into the employer for a while. And this is important because at the moment, sometimes with our clients, we look at it and say, well, actually they've got about 4 months to bring a claim, and then when we get past about 5-6 months, we think, oh, 6 months certainly. We think, oh, we're probably in the clear now. They're probably not going to bring a claim. It's going to be much longer, the wait and see. So it could be up to 10 months. Potentially even longer before we find out if an employee is going to bring a claim. So first of all, there's the uncertainty around that, waiting to see if someone's going to bring a claim. The second thing is that we've got to keep really good records. We are placing a lot more focus now as a team and taking witness statements early before memories fade to ensure evidence is reliable, because not only are the claims, they've got longer to bring these claims, but when the claims go in, it's much longer before they're actually heard in tribunal. Like I said, at the moment we're getting claims in without this 6 months time limit. We're still at the original 3 months, and we've got claims listed for 3 years from now. So it's really important with the delay in ET claims running several years. It does cause issues with not only memories fading, but key witnesses leaving the business long before the case even gets to tribunal. So that's really important because we need to consider adding clauses in our contracts which require post-termination assistance with legal and regulatory processes. So we do this often in settlement agreements. If somebody leaves under a settlement agreement, what used to be called a compromise agreement, we'll include a clause to say you must still support us on regulatory and employment matters. And if we have a particular case where they are a witness, we'll actually factor that particular case in as well. But I think for anybody, if you have a witness who is to a dismissal, who's going to have to be in a tribunal and they leave you, it's obviously harder to be able to control people once they've left our organisation. We can subpoena witnesses if they won't appear. So the best thing we can do is to get a statement off our witnesses as soon as possible. So we work with our clients to get our witness statements as soon as possible. And then if that witness then leaves the organisation, then we have to, and they won't, we ask them to give evidence, but they refuse, and we have to subpoena them to give evidence. So we have to force them to turn up. At least we've got a statement that they wrote while they were with us. So then if they decide, if later on they're hostile and they decide to sort of divert from that statement, we can rely on the statement that we have. So it is really important in terms of when you're looking at the kind of people who are going to be doing your grievance hearings, grievance appeals, your dismissal hearings, your dismissal appeals, they're the people potentially going to be a witness in the tribunal. So given this long period of time that we might have, we need to make sure that we keep very accurate records of what's happened, and if claims do go, and we start working on those statements sooner rather than later. So there's other, so Padma touched on some trade union rights. So there's some that were brought in February, which are quite specific, and there's the ones that are coming in April. Now we've also got more coming in October, and these are relevant to all employers. So some of you may have union involvement, some of you may be unionised. Some of my clients in the care sector have union, a lot of people in their unions, and some don't. But these new October changes are going to apply to all employers. So even if you don't have a relationship with unions, or even if your staff aren't particularly unionised, this will affect everybody, because employers are going to have a legal duty to give a written statement reminding employees of their right to join a trade union. So I think the change that coming in, they call it the golden era of trade union rights. So it starts with the employer informing, a proactive obligation to inform an employee, because obviously employers can't stop their employees joining trade unions, but this is about having to inform them first that they have this right to join a trade union. And this written statement must be given at the same time as their Section 1 statement, so their employment particulars, their contract to employment at the beginning of the employment. And then it's also going to have to be given again to the employees at other prescribed times, as going to be fixed by regulations. So we don't know what these prescribed times are going to look like. It could be that they've got to be told once a year. We're hoping it would be once a year, not on an anniversary of them joining, because that would be a bit more administratively difficult to try and keep up with that. But the government are really keen on this, because the measures are designed to inform employees about their right to trade union membership, and it aligns with the government's broader objective of empowering workers by ensuring that they're fully informed of all their worker rights and all the rights they should have in their job. It's also a key part of the government's wider commitment to strengthen worker voices in the workplace. They want to enhance representation and ultimately improve working conditions through increased trade union membership and participation. So the government is intending to bring this requirement into force in October 2026. So again, like I say, we don't know yet what the trigger is going to be for reissuing these. We hope it's going to be a fixed annual date rather than their start date, but we will know more when we see the regulations, and we will update you when we do know. So it is similar to the current Section 1 regime. So you have to send a Section 1 statement or a contract of employment with the basic employment terms. So if you don't do that, there's a fine of penalty of minimum of 2 to 4 weeks pay. So this is going to work the same way. So if you don't send this requirement to tell the employees that they have the right to join a trade union, that you'll be subject to a penalty of 2 to 4 weeks pay if you don't do that, and they bring a tribunal claim. So it's going to operate very similar to if you don't give them an employment contract, that type of claim. The next part, and this is perhaps more on a practical note, the ERA 2025 is introduce a regulated process that gives trade unions new rights to access workplaces so that they can actually meet, represent, recruit and organise. So unions are going to be able to submit formal access requests to employers who must respond within a set time frame. Employers and unions can then negotiate a written access agreement. But if the employer does not engage or negotiations break down, the Central Arbitration Committee will step in and determine the terms of access. So if the employer then refuses to comply with an existing access agreement, then the TU can apply to the CAC, who can issue fines. We don't know what the fines are going to look like. Regulations are going to specify how much these will be and the circumstances they can be awarded. I think the main thing to note here is until we see further details in the regulations, it seems that this right is not restricted to recognised trade unions. So an employer may not recognise the trade union that is requesting access, or in fact, they may recognise a different union. So it seems that it's not actually restricted to those that are recognised. The second thing to note about this access right is until we see further details in the regulations, it seems that the union does not have to demonstrate that it even has any members amongst the current workforce, let alone a minimum percentage of members. So again, it's all about facilitating union membership and being able to get on the sites to be able to recruit members. The government intends to bring this into force in October 2026, but most of the finer details about these rules will be found in the regulations, which we are expecting later this year. Often we know as practitioners that regulations that bring acts into force and flesh out the details are often brought in just before the act actually comes into force. So if this is due to come in October 2026, often the regulations will appear 2 weeks before. So what we do as well with our clients is for lots of things, we look at what might happen and we try and prepare our clients in advance. But yeah, like I say, keep up to date with us and we'll let you know. So I'm going to look now at just a bit more closely about what the actual access agreements is going to cover and permit. So like I said, there was 2 clear purposes for workplace access. So the first is to enable the unions to meet, support, represent, recruit and organise workers. And the second purpose for this is to support collective bargaining. So these rights apply whether or not workers are already union members. However, it's really important to note that the legislation is really clear that this access right, it doesn't mean they can use this access in order to organise industrial action. This is expressly excluded. So it's not about them being able to come on your site to start conversations about strikes. This is about being able to come on your site to have conversations about recruitment, to support people, to represent and to do collective bargaining. So it isn't to enable them to be able to have discussions about the strikes, although there are details coming later, which we won't go through in too much detail today, about lowering the threshold for striking. But these access rights are not about that. The permitted access rights, though, apart from not being able to discuss strike action, they are broad. I say so. For example, the trade union could ask to physically enter a workspace, to set up a stall in the staff room to recruit, for example, or a stall in the car park or something of that sort. Or they could ask to communicate by email sent to the whole workforce, or provide them with information about the benefits of seeking a collective agreement. So there's both physical and digital access, and we are not excluding either. So it can be both physical and it can be digital. So whilst the employer and union, the idea is it's better to agree. So what I'm saying to clients at the moment is some of my clients have kept unions at arm's length if they feel they can, but I'm saying to them, look, you know, if this is coming in, you know, unions who are already knocking at your door, you're better to agree these access agreements and do it on a voluntary basis, perhaps through a collective agreement. So we do a lot of collective agreements with our clients where we bring the unions to the table and we sort out what their access is going to look like. So this is before even this access came in. We look at what facilities time they can have, what meetings they can have, how they can organise and recruit. And we do all of this with the unions for our clients, so that our clients have control of this, and our clients are able to do something that works for them. So what we're saying to clients, if you're at the moment keeping unions at arm's length, if they're already knocking at your door, you might be better to bring them in and start looking at these voluntarily under a collective recognition agreement, rather than waiting to see what's forced on you. Because if you don't, then, you know, the union, like I say, can serve notice for access, and the whole idea is that you're supposed to facilitate this. So it's not about disrupting your business or anything like that, because employers aren't going to be able to just say no, we can't do it because it's disruptive. The employer is going to be able to have some choice about when access is given, so it isn't disruptive, but we can't just use it's going to be disruptive as a reason. That, you know, we've got to facilitate this, because when the employer and the union cannot reach an access agreement, then the CAC will just step in and they will apply a set of guiding principles. So the focus is in ensuring that it doesn't unreasonably disrupt the business, but it is requiring the employers to take steps to facilitate it. So the other thing that the CAC will be able to do is they'll be able to balance this physical and non-physical access, and they're going to make it clear that neither can be refused simply because the other is available. So just because you allow the unions to talk to your staff in person doesn't mean to say you can then deny email access or vice versa, because unions often want to use a mix of physical in person and digital access. So perhaps access to be able to put some message on the intranet, or to be able to email workers, but also to be able to meet them in person. So full refusal of access should only ever occur where it's genuinely reasonable in all the circumstances, and this is going to be exceptionally rare. A code of practice is going to give us more clarity on this in due course, so look out for consultation later this year. So a lot of these aspects, as well as waiting for regulations, there's consultation going on to see what these regulations are going to say, because the consultations has to happen between unions and businesses to look at these, sort of flesh out the details of how this will work in practice. But just the main takeaway from this is that there is going to be this aim of facilitating union access. So it's going to be very difficult to prevent it. So actually, it's better sometimes for the employer to take the first steps and organise something that suits them. And that's what I'm working with a lot of our clients to do at the moment. So the other big change that's coming in October is the widening of the existing sexual harassment preventative duty. So this amendment doesn't mean it's more likely for sexual harassment complaint to succeed. It relates solely to the tribunal's decision as to whether to uplift a successful claimant's compensation by up to 25%. So the Workers' Protection Act brought into the Equality Act back in October 2024, this sexual harassment preventative duty, which basically means that sexual harassment has always been unlawful, but now employers have to actually take preventative steps to prevent sexual harassment happening in the first place. And those were lots of steps, and we looked at this when we first saw this duty was going to come out. And again, we actually got regulations from the government 2 weeks before, I think. But we looked at what that would look like in practice, and we were right in terms of the measures employers needed to take. And at the time that this was enacted back in October 24, the employer had to take reasonable steps. Now, we knew that the Labour government had put all reasonable steps, the word all, in their manifestos, and we also knew that they were including third-party harassment, sexual harassment. There's other third-party provisions I'll come on to in a moment, but even though that was not included in the sexual harassment provisions that came out in October 2024, this is what the widening of the duty is going to be in October 2026. It's going to be for all reasonable steps and to include the third party. Now, we anticipated that would be the case. So the training materials that we've put together actually cover the wider duty. So if you haven't already trained your staff, so part of the sexual harassment prevention duty includes having policies up to date, proper procedures, proper reporting lines, engaging with the staff about the risk, assessing steps to remove the risk, and anti-harassment training both for staff and for managers. If you haven't done any of those things, then you need to do those now. If you have done training and you're not sure if it covers the all reasonable steps, or you've taken some steps which you think are reasonable, but you're not sure if you've gone far enough, then we have got training that does cover the all reasonable steps. So you can start doing it now if you wanted to bring yourself in line by October. We actually produced a half-an-hour video, which I looked at all the elements of staff training that the EHRC, so that's the Equality and Human Rights Commission, who brought this act into force in the first place. I looked at all the elements that they wanted to be included in all staff training, and I put them into one half-an-hour video. This one half-an-hour video is £750 fixed fee. You can use it for as many staff as you like. It's like I say, it's good. It's good law for even the future. So it works for now, and it works for next year and the year after. You can use it to refresh your training. So you can roll it out every year. You can put it in new starter induction packs, and it comes with a workbook. So as a minimum, I would say, whether you use us or you use another provider, please train your staff as a minimum. Make sure you've got your policies in place, because the duty is there now, and it's only going to expand. So the problem you've got when it looks at all reasonable steps is that if there is a complaint brought at a tribunal, then if the steps that the tribunal believe you should have taken but you did not, then by definition you would have not have taken all reasonable steps. So I think it's really important to look as an organisation where your risks are, and as a minimum have your policy, have your staff training. There's other things you can do, but as a minimum I'd say make sure you do those two things. So as well as the increase to the sexual harassment duty, there's going to be an extension to all third-party harassment. So by harassment, we mean all of those elements of other protected characteristics. So racial harassment, harassment for a disability, gender reassignment, all of those areas are going to come into the protection. Now, it's currently at the moment very difficult, although not impossible, for an employee to bring a claim against their employer for harassment that they suffer from a third party that they encounter through work. But this new protection against third party harassment is going to come into force in October 2026. So I don't know if anybody remembers this, but there was a version of third-party harassment that was in force between 2010 and 2013, which required a pattern of previous incidents on at least 2 occasions before an employee could bring a claim. That was then removed, and it's not been back since in the last sort of, what's been 13 years. But now it's going to be brought back in for all forms of harassment. And with this new version of legislation that's coming in October, 1 incident of harassment is going to be sufficient if the harassment occurs in the course of employment and the employer has not taken all reasonable steps to prevent it. Now, I know that a lot of my clients are very nervous about this because the third parties often can be quite unpredictable. So if you've got in the care sector, you're dealing with vulnerable adults, perhaps you might be a bit more unpredictable. I've got clients who are transport logistics, drive buses. I've also got those who move prisoners about, and all of their employees are very vulnerable to this third-party harassment, as they are in hospitality as well. And it's really, and a lot of my clients are very nervous because, of course, we're saying 1 act of harassment by a third party and the employer is going to be liable for this. What are they going to do to prevent this? So again, they've not told us exactly what this is going to look like, but in the same way that I looked at sexual harassment before it came out, I think it's going to be an extension of that. I think that what I'm encouraging clients to do, so we're going to put together a set of policies and procedures and training about third-party harassment, to keep an eye out for that. But what I would say is that taking these proactive preventative steps and undertaking risk assessments will provide your defence. So in my experience from implementing the previous iteration, if you make sure your sexual harassment is up to date and done well, we'll be able to then lift what you've done with that and put that in terms of third-party harassment. So the more you consult with staff bodies and trade unions and listen to their concerns and agree how to mitigate them, the less likely you are to face claims. So the better your risk assessments are. So do what you've done with sexual harassment, or if you haven't done that, make sure you do that now. Look at your risks areas, so lone working, being alone with clients, service users. Look at all those areas where you're most at risk and you're most likely to face claims. Talk to your staff about it, talk to the unions, make sure you've got the risk assessments in place, then get your policies and your training in place. So like I say, we will keep you up to date with what we know as it comes in, but if you've got your sexual harassment boxed off, you'll be able to lift that. And I think that even if we don't see what the harassment provisions are till very late in the day before it comes in, if a claim was brought against you for third-party harassment and you've tried all these steps, I think it would be much easier for you to be able to defend claims. So I'm going to hand you back over to Padma now, who's going to take you from the 1st of January.
Thanks, Caroline. And as Caroline says, we do regularly send lots of updates. So again, if you're interested in those, put that on your feedback form and we can add you to our free mailing list. But also, if you want to connect in with Caroline or I on LinkedIn, and our profiles should be on your screens, then please do, because again, that's probably one of the faster ways that when there's any new case law or updates or any changes like that, Caroline and I tend to post quite regularly on our socials, don't we, Caroline, in order to bring clients and contacts up to date. So do connect in with us. So I'm going to go from the 1st of January and a few more significant changes that will come in. The first one being unfair dismissal, which I think is probably is one of the ones that was most talked about in Labour's reform proposals of would it be a day one right where from the very beginning people will have an unfair dismissal right, which currently individuals need to have 2 years qualifying service to bring ordinary unfair dismissal claims. So by ordinary unfair dismissal claims, I mean those types of dismissal claims where there isn't any element of discrimination or whistleblowing attached to it. The change, as it's ping-ponged through, is now going to be changing that 2 year qualifying period to 6 months. This would have been the most radical change to unfair dismissal law in over 50 years, because, as I say, the bill originally suggested that it become a day one right. But ultimately, the government was unable to persuade the House of Lords to vote in favour of this, and it ping-ponged back and forwards. You know, as I say, the bill just kept going back and forth through parliamentary debates. So to break that deadlock, there was a last-minute agreement reached with key stakeholders around unfair dismissal elements, which then replaced it with a simple requirement of a 6-month qualifying period, which obviously is a lot less dramatic than a day one right. And I think obviously a sigh of relief for most employers, albeit not necessarily the position that we're in now of having that 2 years service that is needed. That 6 months requirement will come into force from the 1st of January 2026. So anyone with 6 or more months service on that date will immediately gain unfair dismissal protection. So in practice, it means that if you're hiring now, people are likely to gain unfair dismissal protection by the time it gets to January 2027. Other employees, as we say, will reach that protection once they get that 6 months of service. The Act, and the way this has changed, removed the statutory power to vary that period by regulations. And without trying to get too technical, what it ultimately means is any future changes in government can't, as we've historically seen, where it can yo-yo up and down from between the lowest it's ever been is 6 months, and then highest at 2 years. But for a good period, we had it as 1 year. So if any government came in to say, actually, we want to bring it back up to 2 years or even find that middle ground of a year, it's not a simple, quick change that can be made. It will have to go through a primary legislation change, which has a whole heap of red layer tapering around it to be able to make those changes. So having a 6-month period in which to assess whether a hire is a good fit will mean that you have to ensure that you have a solid induction process for any new hires. And it's not going to be a case of just allowing to sink or swim during those first few months. And this is where probationary periods, which aren't mandatory in law, but very common as a contractual principle that most employers have, becomes even more important. And it's really important that managers are trained to understand the importance of not letting problems drift and assessing and keeping on top of how people are getting on quite early on in their career. So often do I get a call at 18 months, close to the 2 years, to say, do you know what? This isn't working out. It hasn't been working out for ages, but we just, you know, we were hoping that it'd improve, or the manager didn't bring it to our attention and we didn't really think about what to do, but can we get rid? At the moment, whilst, again, 9 times out of 10 subject to there not being any discriminatory or whistleblowing issues, subject to serving notice, I can still easily support employers to have that parting of ways with limited risk. But with this change coming in, it will become really hard. So it's really, really important. And if any message that I can send through this portion of the training that we're doing is really think about training your managers of what probationary period means and how to have those difficult conversations, and really make use of those probationary periods in a meaningful way, and not just having it as a notional thing of it's probationary period, so it means that we might be able to get rid of you. We might be able to get rid of you with a shorter notice period. It is a lot more than that. And when looking at that probationary period, look at the duration. So currently, we typically see a lot of probationary periods being for 6 months or 12 months, and actually, or even a lot of people may say 3 months with a 3-month extension, which does take you to the 6-month period as well. Now, you may want to think about having 3 months with only a month or 2-month extension. So you're only getting to that 4 or 5 months, which may make it easier and make that concerted effort in terms of all those trigger points for you to really make sure you're assessing it. So make use of calendars as well. Make sure that you are properly diarising when you're hitting those trigger points so that you are properly assessing it and not allowing someone to inadvertently drift over and tip over into that 6-month extension period. And as we say, it's about making sure that you've got a method of assessing and assessing it in a fair way within that 6-month period. Caroline has mentioned some training sessions that we do, and actually a couple of weeks ago, Caroline and I filmed some training sessions, and one of them was around probationary periods and how to effectively have those difficult conversations and really maximise those. So again, if you're interested, put that on any of your feedback forms and we can certainly give you more information about those. But it's really important to really think about this and not let this drift. The other thing from 1st of January will be unfair dismissal compensation. And this is a last-minute deal that was reached between the government, trade unions and employer representatives just before Christmas, which resulted in the Act then being able to pass through and everyone reach agreement. Currently, if someone brings an unfair dismissal claim, the compensatory cap is capped at the lower of 52 weeks pay for the individual or 118,223. So that means that when we are advising on any unfair dismissal claims, we can, as advisors, with some certainty say, this is the maximum amount that you are looking to pay out. And we have circumstances where, based on that assessment, employers are willing to take certain risks in terms of whether they proceed with the dismissal or not, knowing that they can make provision in their account or know what that compensation may be, or even use that as a negotiating tool for a settlement agreement. This will become much harder because for any dismissal occurring on or after the 1st of January, that compensation is uncapped. Just to bring it back into reality, though, a little, whilst it does make those calculations and negotiations a bit more difficult, in practice, not to have that as a scary headline, which is what I think a lot of people are seeing in the media, when we're seeing claims for unfair dismissal succeed at an employment tribunal, there are only few compensatory awards that reach that current cap. To give you some stats, in 2023 to 24, there are about 650 awards for unfair dismissal claims in employment tribunals, and those are the reported ones, not the ones that went on to settle. And the median award for those was just over £6,500. So you can see that's nowhere near the cap. But where this cap being removed comes in is really where you're coming to people who are trying to suggest that 52-week cap barrier should no longer apply, but also for the higher earners, because currently that is where higher earners are currently prevented or look at negotiating exits rather than testing that unfair dismissal claim in a tribunal, because they know that if they are that big earner, then the cap of 118,000 doesn't quite get them to what they feel their losses would otherwise be. So it's one of those things that, yes, is a dramatic change, but again, to question how much it will change things, it just makes your calculations a bit harder in certain circumstances. Now, the government argues that lifting this cap is going to deter employers from, as I say, treating the cost of dismissing employees fairly as part of a business as usual expense. As I mentioned, some consciously will just carry on with that dismissal, knowing that they can calculate that risk. But also, the government, the other reason that they used as to why they abolished the cap was to reduce the incentive on claimants to construct more complex cases. So what we tend to see is, alongside an unfair dismissal claim, sometimes to get over that hurdle that you currently have of needing a 2-year service requirement, but also to try and get over that cap, a lot of people try and shoehorn a discrimination or a whistleblowing claim in, so that the cap is lifted completely, and it just allows them to negotiate or be in a better negotiating position as a claimant. And so the government thinks that by doing this, it might stop those complex claims, which then carry on adding to the employment tribunal delays and the backlogs that we are currently seeing. So as I say, the biggest impact will be on high wage earners, but to me, I think that the bigger thing is around the 2 years service and that reducing to 6 months. But do be aware that the compensation cap has been lifted. The other reform is around spent convictions. And what the Act does is it removes the minimum service requirements for unfair dismissal relating to spent convictions. So currently, with regards to a spent conviction or failure to disclose a conviction is not a proper ground for dismissal. But if you do dismiss someone, currently someone would still need to bring would still need 2 years in order to bring a valid claim. The Act removes that requirement for any minimum period of qualification if they feel that there has been a dismissal or a revocation of a job offer relating to a spent conviction. And the other change to highlight from January, I should say, although the exact date isn't yet clear, is around introductions for firing and rehiring. And what the government has suggested here is what we are calling a triple lock system. So 2 ways in which, if you might change terms and conditions and look at dismissing and trying to re-engage someone, 2 of the scenarios will class as automatically unfair dismissal, with a subject to a severe financial distress defence, which we'll come on to, and 1 ordinary unfair dismissal type claim with a special fairness consideration. So firstly, the Act creates, as I say, a new automatically unfair dismissal reason where, other than where there's severe financial distress, that the reason for dismissal is where the employer tries to make what is a restricted variation, which I'll come on to what that definition is in a second, to an employee's contract, which the employee doesn't agree to. And because the employee doesn't agree to that change, the employer dismisses the individual so that they can either employ someone else who will accept those terms, or what you often see is currently is you offer the individual the right to return immediately with the new revised terms and to carry out substantially the same duties, but with the tweaks that you are wanting to make. So what do we mean by these restricted variations? So we're talking about things like negative changes to pay, but not expenses or benefits in kind, tweaks to pension or pension schemes, hours of work, changes to the number of hours worked, specified variations to the timing and duration of shifts, the amount of time someone can take off, or any contractual terms around putting in to say, we can make these changes without your consent. And then there may be some others which they've just said other matters to be specified when we get to setting the regulations. So we're looking at things like, if, for example, you are an organisation where current work times are 9 to 5, and because of demands, needs, any other changes, you decide that actually you want working hours to be 8:30 till 5 or 8:30 till 4:30, or shift it the other way around, whichever way you're doing it, any form of tinkering of those hours or changes to pay to go from weekly paid to monthly paid, or vice versa, or changing pay date, all of these, which are typical variations that employers tend to try and do, will be classed as restricted variations, and it becomes much harder to make those changes unless a business can prove that they're making the changes because it's in severe financial difficulties and it couldn't avoid that difficulty without making the restricted variation. So with that restricted variation, you need to show that that's going to eliminate, prevent, or significantly reduce or mitigate the effect of whatever that financial difficulty is, either now or imminently possible for the employer, in order for it to be able to carry on. Now, I guess we need to wait and see for case law to come through, how it's interpreted, how exactly it's drafted in the legislation. But it's not about improving profitability. We think it's going to be more about business survival, i.e., if we do not make this change, we are going to go insolvent or go under, which is obviously quite a high burden or threshold to meet. The other automatically unfair dismissal situation when it comes to fire and rehire or replace is where we've got, again, subject to the severe financial difficulties test, the reason for making the change, or the principal reason, is to replace the employee with someone who is not an employee of the employer. So you're wanting to change to a model where you use more agency workers or even self-employed contractors. So think of the P&O ferry type situation. Or we're hiring a new person to carry out activities that are the same or substantially the same undertaken by the dismissed employee prior to the dismissal. And the requirements of the employer's business haven't ceased or diminished, or are expected to cease or diminish. Now, for this type of automatic unfair dismissal, it doesn't matter if the employee replaces themselves. So again, typically, this will cover those scenarios that we see where an employee stops being an employee, and because of the model that the business feels works, or even the employee wants to as well, that they then take on a self-employed contract, which is obviously less of a guarantee of hours and less protections. But that's what the second of those triple locks will cover. And then finally, as I say, we've got this new ordinary unfair dismissal claim where the only or principal reason for the dismissal is that the employer is seeking to make a non-restricted variation, so not to do with pay and the other things that I listed earlier, to the employee's contract, to which the employee doesn't agree, and they're dismissed, so that you can re-engage someone to then do the same or substantially the same duties under that varied contract, but it's not to do with one of those restricted variations that we mentioned. And so with that, in terms of a defence, it's not as onerous or as strict as needing that we're in severe financial distress. It's more about looking at the overall picture, the reasons for the variations, and carrying out that proper and fair consultation to try and agree that change with the individual. As I say, right now, we don't have a specific date of when that'll come in, but we're looking at January 2027. I'm going to hand over to Caroline, who's going to then just look at a few more bits that are going to come in waves hereafter.
Okay, so we're just going to look a little bit further ahead because 2027 is going to be a big year for ERA implementation. Just going to go through some major headline changes and just look at things that will focus a bit more on the care sector. Starting with the new collective redundancy consultation thresholds are going to change. Business-wide redundancy exercises, regulations are needed and a public consultation is going to carry on, but what this means is when we're doing redundancies for 20 or more employees, the law as it currently stands is if there's 20 or more employees at a specific establishment, then the duty to collectively consult kicks in. Now that's established case law that it has to be 20 or more employees at each establishment. Now the government were looking to bring in these collective redundancy consultation thresholds much wider and incorporate if there's 20 or more employees across all of your workforce, which can be very difficult to manage because you don't know where, you've got to keep an eye on what's happened down in Kent and what's happening up in Scotland to be able to decide if there's 20 or more across your organisation. So there was a little bit of to-ing and fro-ing, and we're going to find out exactly what this is going to look like in terms of how they're going to impose it. So the government's preferred option is a single fixed number of between 250 and 1,000 redundancies across the whole business, or it might adopt a tiered approach where the threshold would vary depending on the employer size. So they might say if it's 250 redundancies for organisations within, say, 0 to 2,499 employees, going right up to if there's 750 redundancies for organisations with 10,000 or more employees. So we're going to wait to find out what that means. But the important part for you is those of you who have different areas and sites and different areas where you have care homes or different areas in which you operate. If you're going to make redundancies, there is going to be some different rules about at what point we have to collectively consult. So it's not going to be as simple as it is now. Just to the other things on this list, the mandatory equality action plans. I'm not going to go into too much detail, but these are relating to not just the gender pay gap, but for things like menopause support. These are not going to be put in place this year. They're looking at what they're going to include, and they're going to be voluntary, and then eventually they will be mandatory. We are going to have some extended protection against dismissal during or after pregnancy, family-related leave. This is, we're not sure exactly what this is going to look like, but it's basically the protections that we have at the moment for women returning from maternity leave, or whilst they're pregnant, they have certain protections against being made redundant. These protections are extended for other family-related leave, so not just pregnancy and maternity. And we don't know exactly what the protection is going to be. So you've got the protection against being made redundant if you've taken maternity leave, but we don't know yet if the protection is going to be extended to dismissing a woman in any way if she's taken maternity leave, or an employee in any way after taking family leave. So we don't yet know what that's going to look like, but essentially the government are going to put more protections in place for that. So we'll let you know what they are when we find out. There's also going to be strengthened protection against blacklisting. So that, in other words, the basis of that is not looking to not employ people because they are trade union active. So it prevents you having what we call a blacklist of people that are active in the trade union. There's going to be strengthened protections against that. So we're restricted from we can't not employ them just because they're active. The next thing I want to look at in a little bit more detail here is the flexible working, this new reasonableness test that's been introduced. So many of you are aware that flexible working changed last year, and it became a day one right. And it used to have a qualifying period you've worked, but now then they brought it in so you can ask for flexible working from day one, and the employer now has 2 months to be able to consider the request, have any hearing, and including any appeal. So that is the position as it is now. And if you are to refuse somebody's flexible working request now, you just have to do it on one of the stated statutory business reasons. So, for example, we can't cover the existing workload. The cost, the difficulty in reorganising the work. There's a list of business reasons. Now, what's going to change? In 2027, we're not sure of the date yet, but a new reasonableness test for flexible working requests is going to come in. So it's not just that you're going to have to use one of the statutory business reasons to refuse a request. The Employment Tribunal is going to closely examine your rationale for rejecting this request. So the government is currently consulting on the consultation process that the employers must follow when they're unable to immediately accept a statutory flexible working request. So in other words, what's going to happen is if you are going to accept a request, then that's fine. But if you're going to reject a request, you've got to show that you were reasonable in rejecting the request, not just that you've used a business reason to reject. You've got to be reasonable in using that business reason. So we don't know yet how the tribunals are going to measure this, how they're going to determine what's reasonable, what's not, because every different employer has different reasons, and what's reasonable for one employer to refuse is not going to be reasonable for another. So, for example, in a big law firm like Hill Dickinson, it'd be harder to refuse a flexible working request because we have more resources to cover it. But if it was a small own-operated businesses with 5 employees, then they're able to refuse flexible working requests more if they can't cover the work. So how the employers are going to assess what's reasonable and what's not, and across different sectors, which are very different as well, because I know in the care sector, a lot of my care sector clients, there's a lot of they might be caring for somebody, and the continuity is important because they may have certain needs where it's important to have this continuity of care. And if there's flexible working patterns, sometimes it doesn't always work out. It's not always as easy to incorporate. But we're waiting to see how they're going to test this reasonableness. But it will be an objective test looking at the size and resources of the employer. And to determine whether it was reasonable, probably the same way as they look at if there's a case for unfair dismissal, the tribunal will look to see if an employer acted reasonably, carried out a reasonable investigation, and their dismissal was a range of reasonable responses. I think it's going to be something like that. They're going to apply a reasonableness test to whether or not the employer was reasonable in refusing the flexible working request. what I'd say now, though, is what we know that this reasonable element's going to be coming in. So what I would do now is get your managers in the habit of dealing with flexible working requests properly. So in other words, making sure they meet with the employee. If they're not going to accept the request, making sure they have a proper meeting with the employee, consult with them, and have proper evidence as to why a request is going to be refused. So it's not going to be as easy to refuse. So, for example, if the reason that you want to refuse a request is because somebody wants to work a pattern of work, say Monday, Tuesday, Friday, and you think, oh, we're going to refuse because we're not going to be able to recruit for the Wednesday, Thursday, then actually it's not going to be reasonable to refuse for that unless you've actually tried to recruit. Of course, that means you've got to try and do this within the 2 months you've been given to look at the request. But I think when you're trying to do something to be flexible, often the employee will be happy for you to take longer than the 2 months if you're actively trying, for example, to recruit in order to see if you can give this flexible working request. It also allows for trial periods. I would always say if you're not sure if something will work or not, have a trial period. If you have a trial period and you're able to demonstrate it doesn't work, then you have evidence to show why it wasn't reasonable to be able to grant that request. If you're going to have a trial period, be very careful to make sure it is stated as a trial period and that it reverts back to the employee's normal terms and conditions. I know clients in the past have come to me later and said, oh, we granted something on a trial basis, but we've just let it run on and now we want to change it. Well, it's very difficult to then change something back if actually a trial has gone on for so long that they've been working under those conditions and it was pretty much part of their terms and conditions, and actually it's very difficult to say it wasn't working when they've been working like that for a year. So just bear in mind, trial period is extremely useful and tribunals like to see you using them if you're not sure, rather than refuse a request, but make sure you document it properly to show that it's actually just a trial period. So I would be training managers in how to deal with flexible working requests now, because a lot of the time people refuse is just because they think something wouldn't work or they're not sure themselves or they haven't experienced it. So you need to make sure your managers are carrying out this properly and getting objective evidence as to why things won't work. The other thing that's going to come in is this extended bereavement leave and new pregnancy loss leave. So the bereavement leave at the moment is for parents whose children die, but this bereavement leave is going to be extended to cover more relatives. There's also going to be a new pregnancy loss leave. So consultation on these new rights has closed. So we're just waiting for further details. We should get those soon. It's going to be quite wide, and what I saw during the consultation is they're talking about covering bereavement leave for pregnancy loss. So after 24 weeks, they have the right for maternity leave anyway, but they're looking at sort of pregnancy loss before 24 weeks. But they're also looking at in the circumstances that the pregnant, potentially including where the pregnancy is being terminated as well, having this bereavement leave. So it's going to be a lot wider than, so calling it miscarriage leave is a bit of a misnomer because actually it's going to be a little bit wider than that. So we don't know which relatives they're going to cover for bereavement leave, for which relatives you're going to be able to take bereavement leave for, and we don't know what the pregnancy loss one is going to look like. We just know that these are going to be extended to cover these areas. So like I said, the consultation has just closed, so we should find out hopefully fairly soon what the government intends to do with that. And the other final point, which is very relevant to the care sector, is these 0 hours protections, this guaranteed office shift changes. So with 0 hours and low hours workers, if they're working certain guaranteed hours over a certain period of time, then they can be given those hours as a guarantee. So in other words, if you've got a 0 hours worker and they've regularly worked 40 hours a week, they can then ask for a guaranteed 40 hours a week. Now the period in which they have to work those 40 hours a week before they can have these guaranteed hours, we don't know yet. We think it's going to be about 12 weeks, which I think is quite difficult for employers because we often have seasonal requests. So we might have more, say, 0 hours bank staff working over Christmas to cover care working. And then the work they'll then work like that for 12 weeks and the work will actually decrease after Christmas, so we don't need them on the guaranteed 40 hours that they were working. So we need to look at how they're going to work this. What I would do now, we're also going to have some rules about cancelling shifts and compensation for short notice change shifts. So the idea is that the protection of the most vulnerable workers, the government want protection so shifts can't be cancelled at short notice. If they are, they still get paid. This is also going to apply to agency workers, so you can't get around it like that. What I would do right now as an organisation is do an audit of all your 0 hours workers. Have a look who's working as a 0 hours worker now, so that you can see what potentially guaranteed hours might be offered, because it's going to be an obligation on you to offer the guaranteed hours, not the employee to request them. So if you find you've got it, whilst a lot of organisations like lots of bank staff to work, or lots of 0 hours workers, because it gives them flexibility on who to call upon, actually if all those people are working a certain amount of hours, you're going to have to offer them more guaranteed hours. You might be better to offer fewer workers guaranteed hours, or make sure people don't work over a certain amount of hours, so they only get a lower amount of guaranteed hours, rather than having people on guaranteed hours that you then can't use in the future. So we don't know what that's going to look like yet, and we will let you know. But like I say, now I'd do an audit to make sure that you know what you're using your guaranteed hours, what you're using your 0 hours worker staff for. And that's it. Does anybody have any questions?
Thanks, Caroline. Thank you, Padma. That was really, really, really good. I have a couple of questions, if I may ask. So my first question was, there's obviously a lot of changes to the law, which it is what it is, but how do we practically bring that into our day-to-day operation as care operators, managers? And how do we ensure that we don't sort of make some of the obvious mistakes that could happen if we don't do anything about it?
I'd say audits and training. I don't know about you, Padma. I think know what you've got. Audits, but Padma mentioned holiday pay. Audit your holiday pay. Audit your 0 hours workers. Look at your, check your absence policies. Make sure you manage your absence. Train your managers on dealing with things like absence. Train your managers on dealing with things like flexible working requests. What do you think, Padma? Would you?
I would absolutely agree with that. I would suggest, and something that we're more than happy to do, is maybe have a little checklist of the changes that are due to come into force. So obviously Caroline and I have tried to do it as a bit of a timeline. So maybe taking what we've done as a timeline and having a bit of a checklist of, for example, 1st of January, unfair dismissal changes are going to come in. So prior to that, months prior to that, I'd be having a checklist to say, have we looked at our contracts? Tick. Have we got a probationary policy period? Tick. Have we trained managers that they understand the importance of probationary periods? And that's the thing. I think it's all about preparation, whether it be timetable preparation as well as managers understanding and having some of those, putting aside sort of the legal understanding of some of these, is some of the practical tips of having difficult conversations. Turning down a flexible working request is difficult. Saying someone isn't performing to the standards that they need to is difficult. So are your managers equipped to deal with this?
Yeah, I think what a lot of our clients have done is they put the changes to the Employment Rights Act on like a RAG report. They put the areas that are going to impact them, and they've put, are they ready, green, are the things to amber, are they not ready, red. So that's a really helpful way of looking at your plan of what you need to do. But in terms of, I couldn't emphasize enough manager training. We offer manager training videos to bring your managers up to speed with performance, having difficult conversations, absence management, having even basic things like how to have a proper return to work thing, all the things you can do to reduce absence by training your managers to deal with it properly, conflict resolution, grievance training, investigations training. We do all those on video. Like I say, you don't have to get them from us, but I would just really, really couldn't implore with you more to train your managers, because it's the managers, not HR, who will effectively be managing the staff, and they will be the ones who get you into difficult situations.
Yeah, no, that's very helpful. Thank you. I think that checklist would be great for our audience to get hold of. The second question I have is we just recently heard about how the unfair dismissal rules or protection will effectively begin from day one. How should employers rethink recruitment, probation, performance management, and ultimately, does it really change the way we should hire people in the future?
I think, as I mentioned in my section, it all comes back down to really effective probationary period management and really having rigorous checks when you're hiring someone. So I think what this change will do, it probably is going to minimise those hires that people might currently do where they take a bit of a punt to say, oh, we're not quite sure, but you know what, let's give them a go. That becomes a bit harder to do when you think actually you've got a shorter period to assess someone. So that's the question of, do you still take a punt, but make sure that you're assessing them a lot sooner than you might otherwise have done so and put them on that steep learning curve? Or do you look at your interview processes and what you're checking? So, for example, I know that when we do hires, we tend to go through different layers. It tends not to just be just a one interview and that's it. We might do, you know, is this right for you? Is this right for us type interview? But we might, depending upon what level and what the role is for, we might then do a bit more of a technical interview just to see where they're at and whether and how they approach certain things. So again, depending upon what the role is and where, you may think about certain ways of testing, in inverted commas, of that person's ability before you then make that offer.
Yeah, I agree. I think you get your recruitment right. It's really important because you've just not got as long. I think the key thing is you haven't got as long to check your employees. You used to have 2 years, and sometimes you take a chance with people, which is going to be harsh on employees because people aren't going to take a chance on them as much as they would. But you used to have this 2 years, and it's about being a lot more proactive, reducing, like Padma said in her talk, reducing your probation periods, having more check-ins, better recruitment, getting your objective evidence quicker, and more importantly, the managers dealing with it quicker and having those difficult conversations earlier.
If anything, please just make sure that you're diarising those probationary period points before you get to the probation date. So you've got enough time to get the meeting in the diary, dealing with things like what if someone is about, going to go off sick or be on holiday in that week before their probation is due to expire, because so often we get calls to say, probation's, that period's passed inadvertently because so-and-so was off ill or they're on holiday or we just forgot. And, we've just realised 3 weeks later that they should have had their probation meeting, and it just becomes so much more difficult. So again, at month 4, month 5, you really should start thinking about having those conversations and what that will look like.
Great, brilliant. Thank you so much. I've learned so much. I'm pretty sure our attendees have learned equally the same amount as well. But I really appreciate both of your time.
Thank you. Yeah, so as we've mentioned, feedback is really, really important to us. So please do fill out those feedback forms, including, please do put on there if you think there is a value of us delving into any of these topics in further detail, because I know that Caroline and I were really conscious of time and it was a bit of a whistle-stop tour. So I appreciate we've probably stunned a lot of people into silence through the volume of information that we have given. But by all means, we can look at any sessions where we look at any of these in depth, or even anything else that affects your sector, then please put that on there. Do think about linking in with us, and again, you should have details of our contact information if you do need anything, and we're more than happy to have further chats in terms of how we can help, or any of the questions that come out of this that you didn't feel able to ask today or comes to your mind at a later date. But otherwise, thank you very much for joining us, and we hope to see you at some other event soon. And thank you for PredicAire for partnering with us today for this event.
Thank you so much. All the best.
Bye.
Bye.
Bye-bye.